Good afternoon, everyone, and welcome to today's iteration of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano. I'm an employment lawyer and associate with Samfiru, Tumarkin, LLP. I work out of the Toronto office. So if you guys have any questions, feel free to ask them right now, whether it's through Facebook, LinkedIn, X, Twitter, YouTube, and I'll answer them live. You can also send us questions at help@employmentlawyer.ca. You can go to employmentlawyer.ca or give us a call at 1-855-821-5900. So I'd like to start today by speaking about a case that one of my colleagues, John Pink, has commented on in the Canadian HR Reporter. In that case, there was a laboratory technician who worked for Hamilton Health Science who was dismissed due to poor performance for cause, and an arbitrator upheld that decision due in large part to multiple implemented performance improvement plans, as well as instances of non-culpable conduct. So notwithstanding this case, it's really important to remember that in Ontario, cause for termination, so to terminate someone without paying any termination or severance entitlements, whether under the common law or under the Employment Standards Act, is extremely rare and extremely hard for an employer to prove. In this case, it was very unique, very extreme set of circumstances where it was a very short tenured employee, and there was extreme and serious cases of non-culpable conduct, meaning she was doing her best and she just couldn't do the work. This is an extreme case and is very much an outlier. By and large, if you're doing your best and you are meeting the expectations of your employer, they can't fire you for cause. And even then, it's still extremely difficult for them to prove it. So in any time when an employer is attempting to put you on a performance improvement plan or is intending to terminate you for cause, whether for performance reasons or otherwise, it's extremely important that you contact us at employmentlawyer.ca, and one of our lawyers can help. It's extremely difficult for an employer to make it out. And oftentimes, even if the company is asserting cause, they don't have it. The way our courts treat cause is it's a binary aspect. There either was cause or there wasn't. Courts aren't allowed to say, well, there was almost cause, so instead of giving someone the full severance package that they'd be entitled to, we're only going to give them a portion of it. Instead, the court goes through a two-phase analysis where they say, was there cause, yes or no? And if the answer is no, then that whole cause issue is set aside and you're awarded severance damages and a severance package as if you were terminated without cause, as if it was just a standard without cause termination. So it's really important that you don't accept an employer's word that they have cause and instead give us a call and we can help. There's a question from Aubrey on YouTube. She asked, how many weeks of severance is someone eligible for after 6 years of employment? So Aubrey, how much severance someone is entitled to depends on a number of factors, and they're all fact specific. So the courts look at your length of service, your age, the availability of similar employment, and any other factors that may make it more difficult for someone to find a new job. So only having 6 years, only having your tenure of 6 years is difficult for me to say for sure. But generally, it would be somewhere in that range of 6 to 8 months, but that depends. It could be more and it could be less. Our courts also award what's called a reasonable notice range. So there is some variability in how much could be awarded. And that's because two judges may look at the same case and one might believe 6 months is appropriate and one might believe 7 and one might believe 5, but it's all within that same range. So I don't know exactly, how much you would be awarded, but likely somewhere in that range of 6 to 8 months. If you want to know for sure, you can reach out to us at employmentlawyer.ca, and one of our lawyers can undertake a full analysis of your case, really get to understand the nuts and bolts of your employment, and then we'll be able to give you a full outline and a full plan of what you could be entitled to in court. Got a question on Facebook from Sky. Sky asks, after having to take 2 sick days at my job, my employer said that he's stopped scheduling me. I gave them a doctor's note, but was told I need to suck it up and work harder. Can my employer just refuse to schedule me? Is there anything I can do? No, an employer can't just choose to stop scheduling you. If an employer does that, that's a constructive dismissal, and you're entitled to severance. When you're sick, you're entitled to be off. Both Employment Standards Act protects it and the Ontario Human Rights Code protects it, especially if after 2 days you gave them a doctor's note, they really have no leg to stand on. And the whole suck it up and work harder doesn't apply at law. So no, the company can't just stop scheduling you shifts. So in a situation like yours, it's the most important thing is that you're creating a paper trail and that you are, creating the documentary record of him saying that stuff. While it's conversations are good and that evidence is strong. It's written evidence, whether it's text messages, whether it's emails, whether it's written letters, are always better. So if your boss said that over text, then then that's probably a termination. You can treat your employment as having been dismissed. Otherwise, I'd probably try and get that in writing, and then reach out to one of our lawyers. And that written communication versus oral communication principle applies to almost every situation in employment law. In court, it can oftentimes turn into a he said, she said, right? I said this, and he said that, and then the other side says, no, he said this, and I said this. And it muddies the waters and makes things very difficult. Whenever you're having these conversations and you think your employment might be affected or your rights under your employment might be affected, it's best to get it in writing. Now, that can be something as simple as, hey, boss, following up on our conversation where you said this and I said this, and I'm going to do this. Thanks. That just even sending them that email and giving them the opportunity to respond to it can go a long way in helping a case. Similarly, if you don't feel comfortable doing that, at least take notes yourself, right? Because our courts realize that memory wanes the longer it takes. And, unfortunately, some cases can drag on for quite a bit of time. And it can be upwards of 2 or 3 years before you're in front of a judge trying to remember a conversation that happened in one November afternoon in 2023. So if you can't get it in writing, take notes contemporaneously. Take notes as it happens so that you know what what was said, so you can remember it. And even those handwritten notes, can help be persuasive in a case. Sandy on YouTube asks, she's currently on unpaid medical leave and noticed that the employer has taken her profile off the public website. Position is not listed either. Others on med leave are still there. What to make of this? Well, Sandy, it's a difficult position to be in, right? So while you're on an unpaid medical leave of absence, there could be business reasons why the company has chosen to take you off, right? Depending on a number of factors, there could be a reason behind it. That in and of itself probably isn't enough to establish constructive dismissal or pursue your employer for severance or damages. That, provided they're still accommodating you and provided they are still willing to let you stay on this medical leave. This goes back to the point I just raised in taking notes, making sure you take note of the date it happened or the date on which you realized it happened, so that in the future, when you do decide to go back to work, if they refuse to, if they make it difficult, if they try to return you to a worse position or demote you, well, then now we have this, now we have a series of events. We can tell a more persuasive story in court that says they never intended to bring Sandy back. They always intended to let her go. This was always their plan while she was on medical leave. And the proof of that is that her being taken off the website, X number of months, X number of weeks, years prior to her trying to return. So that in and of itself, Sandy, I don't think there's too much we can make of it, but it's definitely a good piece. It's definitely something you want to remember, and you want to try and keep track of that. So whether you have a journal, whether it's you send an email to yourself, whatever it is, keep track of it now so that if there are troubles upon your return to work, you have that evidence. You're not guessing, you know what it is, and you have something to prove it. Lisa from YouTube asks, when working with a time card for your employee, how much are they allowed to adjust your time before it is considered illegal? They're removing 15 minutes from the beginning or end of shift. Is this allowed? No. So the company's not allowed to adjust your payment at all, right? So they're allowed to do it if there was a mistake, right? So if you forgot to check out for lunch and you have a 1 hour unpaid lunch break, then they're allowed to adjust that. But it needs to be with your permission, with your consent, and they can't just unilaterally reduce your earnings, right? So if they're doing that and they're saying, well, you checked in at 7:42 or 7:45 rather than 8 o'clock, so we're going to dock you for 15 minutes, then they're not allowed to do that. They have to pay you for the time you work. Now, the inverse of that is they can also say, stop coming in before 8, right? And if you continuously are coming in early to try and get those extra 15 minutes, then, you know, it would be difficult for us to get anything. So I think it's, again, email your boss, text your boss. I noticed this happened. Why did that happen? And if they're continuously doing it, you can actually file a complaint with the Ministry of Labor for unpaid wages, right? So the Ministry of Labor guarantees that you get paid, the Employment Standards Act, that you get paid for the hours you work. And if they're continuously on a daily basis, on a regular basis, removing 15 minutes, they're not allowed, and you could be able to recover those damages through the Ministry of Labor. So in your case, again, try to figure out why it's happening. If it's because you're clocking in early and you're being told not to, or if you're staying late and you're being told not to, then that's on you and you can't do it. But if you're showing up when you're supposed to, and the boss is docketing time for the sake of docketing time, then that's illegal, and it's something that you need to first raise with your employer. If you want more personalized, more advice that is tailored specifically to your situation, reach out to us at help@employmentlawyer.ca or at employmentlawyer.ca, and one of our professionals will be able to help you out. Thoughtful Action on YouTube asked, terminated without cause after more than a decade, did not sign termination offer, which is now expired. Worst case, I should still be able to get the same offer, right? And as a follow-up, what's the probability they would reduce the terms of the original offer? So I don't know what the initial offer was. So what the initial offer was in relation to what you may be entitled to in court, it's going to largely inform that decision, right? So the offer's off the table in my practice. Oftentimes when an employee misses that deadline, but then tries to accept it later on, the offer is still held open and they're allowed to take it. It's not always the case, and there's no obligation on the company to do that. And they are allowed to reduce it. However, in doing that, in reducing an offer or saying we're not making you an offer at all, then they're increasing the likelihood that they get sued. So it's unlikely that they would reduce it or that they would pull it entirely, but it is possible. One thing to keep an eye on, though, is that when you're let go, whether or not you sign the offer, whether or not you sign the documents the company is asking you to, you're entitled to your minimum entitlements under the Employment Standards Act. Those are not subject to any discretion. It is very clearly laid out. If you were there for a decade in your case, you're entitled to 8 weeks of termination pay, and depending on the size of the company, potentially 10 weeks severance pay. So you're entitled to 8 to 18 weeks under the Employment Standards Act, and they have to give that to you irrespective of whether or not you sign the release, you accept their offer. So what's really important in a case like this is in any case where you're let go, give one of our lawyers or give us a call at 1-855-821-5900. Email us at help@employmentlawyer.ca or go to employmentlawyer.ca to set up a call with one of our legal professionals. One of our lawyers or paralegals, all of which who are extremely specialized and trained in employment law, will be able to review the termination offer with you, let you know whether it's a good offer, a bad offer, and whether or not you should take it as is, or whether or not it would make sense to retain a lawyer to help you get more. And again, they'll be able to tell you exactly what you'd be entitled to under the Employment Standards Act, what the minimum you should have already be paid is. Courts have in the past punished employers for not giving those minimum entitlements right away. So even if you think the offer is good, even if you think it's fair, give us a call so that we can help you, because there's a lot of pitfalls in navigating the termination entitlements and severance entitlements after an employee is terminated, and one of our professionals will be able to help you out. Glenn Coe asks, what are my rights and entitlements if I work from home in Ontario for a company in another province or country and get laid off? So Glenn, where you live and work is the law that applies, right? Generally speaking. So unless there's a specific choice of law clause, which even those get a little hairy, you're generally entitled to the entitlements you would receive under the Ontario legislation and under the Ontario common law. So if you're working for a company based in Quebec, based in BC, or based in New York State, USA, you're protected by the Ontario Employment Standards Act, you're protected by the Ontario Employment Common Law, and your entitlements are governed in Ontario. So this issue actually comes up a lot where employees end up working for American companies. As you may know, employment law in the US is far, far, far less favorable to employees. Doesn't protect them from nearly as much as the Ontario law provides. So oftentimes, American companies who have a Canadian working remotely will let that Canadian go and think that they don't have to pay them anything at all. That's just fundamentally not true. So then in those instances, it's really important that a Canadian, that employee retains a Canadian Toronto, Ontario counsel to help them pursue their entitlements. So Glenn, to answer your question, in short, your entitlements would be governed by Ontario law. You'd be protected by Ontario law. But again, it'd be important to have a lawyer review your contract before you sign it, or if you're ever terminated, so that they can advise on your rights. And that's true for everybody, irrespective of where you're working, whether you're getting promoted, whether you're currently working for a company and they ask you to sign a new contract, what have you. If you're being asked to sign a contract, it's important to have a lawyer review it and explain what's going on. Employers can oftentimes sneak in clauses, sneak in new terms of employment that seem innocuous to the employee, but really are limiting their entitlements and barring them from recovering, very valuable termination entitlements. So if you're ever asked to sign a contract, whether it's when you start a new job, whether it's when you get promoted, or when you get promoted, when you start a new job, or just because the employer asks you to, give us a call, reach out to us at employmentlawyer.ca, and one of our lawyers can review it with you and tell you exactly what you're entitled to. Sam San on YouTube asks, if your employer is restructuring positions, it is asking existing employees to complete interviews to return to their roles, does that mean they don't owe severance? So, Sam San, it seems like your situation is a little hairy, but if you've been let go, you are entitled to your severance. Our courts have said that employers can't rewrite history. So if you're let go and then asked to reapply for a job, your severance entitlements are paid and owing. Now, if they're asking you to reapply for a new job and interview for it, then provided the workplace hasn't been poisoned, provided that returning to work for this employer wouldn't cause you to work in a hostile, embarrassing, and intolerable environment, then a court would expect you to apply for that job. Now, just because you're offered a job doesn't mean you have to take it. Our courts say that in order to mitigate, when they find a new job, employees aren't obligated to take any job that is offered, right? If you work as an accounts payable clerk making $60,000 a year and you're let go, a court won't say, all right, well, you were let go, why didn't you apply to work for minimum wage at McDonald's, at Burger King, wherever? You only need to take comparable employment. So employment that pays you roughly the same, with roughly the same hours, with roughly the same conditions on your employment. Similarly, they wouldn't ask, you were let go, lived in Toronto, why didn't you apply for jobs in Sudbury? It's very much a situation where you only have to take a job that is comparable, similar to the one you lost. And if being let go and then asking to reapply would cause you to work in a hostile environment, no court would expect you to do that. But your situation, Sam, does seem very fact specific, and it does seem tricky. So I would suggest that you reach out to us and speak to one of our lawyers who will be able to guide you through what you're entitled to. Thoughtful Action asks as a follow-up. So what is the typical time to negotiate a settlement? Can I apply for EI while it's being litigated? While it's being litigated. So the typical time depends, right? So the vast majority of cases do settle, and they settle within the first within the first 6 to 9 months. But that's not a rule. That's not anything. That's just the way it is. Cases can take forever, and oftentimes it does depend on whether or not the company wants to play ball. If the company wants to fight it, if they want to fight it tooth and nail, then it can take months and sometimes years. Now that's rare, but it does happen. So, if you reach out to one of us, one of our lawyers will be able to reach out to the company pretty quickly, and they'll be able to get in contact with the company and try and negotiate a severance package. There are times where a settlement can be reached within a matter of weeks or a few months, but sometimes it takes longer. So it really depends on what the company wants to do and whether they want to play ball and whether they want to litigate this thing. Marilu asks, can I apply for EI while on grievance? So I'm going to be careful with this one, just because grievance is generally a union term, right? So so employment law in Ontario applies to non-unionized employees, and that's the area of law I practice. There's also labor law, which applies to unionized employees, and those are two separate issues. So Marilu, if you're a unionized employee, it's best for you to reach out to your union rep and ascertain what they say, because union agreements can oftentimes vary or change your entitlements under the law, right? But if in the context of employment law, if you've been let go and you're pursuing a lawsuit against your former employer, yes, you can apply for EI in the interim. Now, that will affect how the severance payment is paid to you. As you may be aware, there are repayment obligations under the Employment Insurance Act. But that said, you can still get it. You just may have to repay some of it back afterwards. Catherine on Facebook asks, if my employer moves me to a new department, can they change my hours? I've been working the same schedule for 10 years, but my original contract says I need to be available any time of day. So it does become difficult when an employer is changing departments and when, a change has been made to your employment, Catherine. So if it's a situation where you have worked for the past 10 years, 9 to 5, Monday to Friday, then you're likely, and now they're changing it from 9 to 5 to 8:30 to 4:30. That change probably isn't significant enough to do anything. However, if they are changing your days of work, meaning you're now working both Saturday and Sunday, and instead get Wednesday, Thursday off, or instead of working 9 to 5, you're working 5 to 9, or 5 to 2 a.m., 5 p.m. to 2 a.m. Now that's a significant change. That is something we could pursue in court. It's really a contextual analysis. And if a contract that is 10 years old says that you have to be available at any time, even though it says that because you've worked that one schedule for 10 years, there's a good chance that them changing these hours, if it's significant enough, can constitute a constructive dismissal and allow you to pursue a severance package. So in a case like yours, reach out to us, go to employmentlawyer.ca, and one of our lawyers will be able to really review your whole situation and let you know what you'd be entitled to in terms of severance. Thoughtful Action says, is there an obligation to mitigate during the ESA minimum period? No, there isn't. So during your ESA period, those amounts are your minimum entitlements. Those aren't subject to any mitigation. That is the amount you're entitled to at court, or under the Act. So even if you find a new job during that time, you're still entitled to your full ESA entitlements. Sam San, as a follow-up, said they've said that the restructure of duties means we have to interview to see if we qualify for our jobs. If we don't pass the interviews, we will be moved to lower roles at less pay. So, Sam San, your situation, if they do try to move you to a lower role with less pay and demote you, then that's a constructive dismissal. So any demotion in the workplace, even if it's entitle only, can constitute a constructive dismissal. But in your case, where they say we're going to not only reduce your stature in the workplace, not only take duties away from you, but also reduce your rate of pay, that is a constructive dismissal, not only because of reducing your rate of pay, which in and of itself is enough, but being demoted in the workplace, our courts acknowledge is embarrassing, can lead to someone having to work in a hostile work environment. So if they do decide to demote you, don't accept it. Don't say anything in writing that seems like you accept it. If that happens, give us a call immediately. We'll be able to tell you what your rights are. And if that's the case, you'll likely be able to receive a full severance package. Okay, so we're coming up to the end here. So let's answer one or two more questions, then we'll be all set for the day. So Cindy on YouTube asks, if you have to leave a job because your employer is not willing to accommodate physical limitations, would you be owed any severance? Been in my job for 25 years, but have developed some chronic conditions. So Cindy, it depends on a lot of things. So under the Ontario Human Rights Code, an employer has a duty to accommodate employees up to the point of undue hardship. What is undue hardship? Is always the question in cases like that. But generally, it is a very hard standard to meet. It's a very hard threshold that an employer has to satisfy in order to say that accommodating you would have caused undue hardship. So in your case, if the accommodation you needed was being able to work from home 2 days a week, or it was different hours, or it was different duties, the company has an obligation to accommodate you. They have to make efforts to allow you to work, to facilitate your continued employment. A company can fail in its duty to mitigate in one by refusing to do it, but they can also fail in their duty to mitigate or to accommodate, if they don't take the necessary steps. Not only do they have to see if they can change your job, but they also, if that job can't be modified without creating undue hardship on the company, then they also have an obligation to look for other roles within the company that you could do. As an example, if you were, if you worked behind a computer every day, but then got carpal tunnel and couldn't do that, well, they would need to see if there was another job in the company that you could do instead. Now, there are instances where an employee's job can no longer be performed, right, as a result, and it would create undue hardship. And if that happens, then your employment would be frustrated. But when employment is frustrated, you're still entitled to a severance package, right? And frustration is extreme. Again, it's hard to prove. It would occur in a situation, for example, where you have a pilot who loses his eyesight. In that situation, the employment would likely be frustrated. But even then, there needs to be a contextual analysis. So, Cindy, if they're refusing to accommodate you, it's very important that you reach out to us at employmentlawyer.ca. One of our lawyers will be able to tell you exactly what you're entitled to. By the sounds of things, by your question, it sounds like you've been constructively dismissed and you're entitled to a full severance package. But if that's not the case, your employment's frustrated and you're still entitled to something. So give us a call. One of our lawyers will be able to help you out. So that's it for me today. It was a pleasure speaking with all of you. Our next employment law Q&A is at 1 p.m. Mountain on Monday, November 6th with my colleague Luke. He'll be able to answer any questions related to Alberta employment law or employment law in general. Again, our website is employmentlawyer.ca. Our email address is help@employmentlawyer.ca. And our phone number is 1-855-821-5900. Thanks, everybody, and I hope you have a great Friday.